My name is Araceli Turmo, and my paper today was on nebis in idem and recent developments concerning this fundamental rights in the case law of both European courts, the Court of Justice of the European Union and the European Court of Human Rights. These recent developments concern a very specific aspect of this principle, which has to do with double-track enforcement, i.e. the cases in which you might have both a criminal law response and an administrative law response to the same sets of facts. And in certain cases, this can actually be in principle incompatible with nebis in idem in case we consider the administrative side to be of a criminal nature. And in recent years, in 2016 and in March 2018, the European Court of Human Rights and the European Court of Justice have rendered decisions that, in fact, overrule previous case law in order to take into account some of the member states or certain member states' concerns about the broadening of the scope of nebis in idem, which they saw as preventing them from developing their own policies in those areas. And what's interesting is the European Court of Justice has tried to reach some kind of a compromise with the European Court of Human Rights by refusing to follow the precedent as it was set by the European Court of Human Rights in terms of the standard for this fundamental right, but at the same time trying to reach a similar solution in European Union law, but through a different path. And I believe this is a manifestation of broader differences between the two courts and the way in which they perceive fundamental rights, and more specifically those to do with procedural law. And also, interestingly, a case in which the European Court of Justice seems to be trying to position itself as a better protector of fundamental rights, but in a very specific case, than the European Court of Human Rights. While the European Court of Human Rights gives more leeway to member states to create their own solutions for double-track enforcement, the European Court of Justice, at least in cases that involve the implementation of EU secondary law, seems to be introducing stronger control over national law in this regard.